Berg with Wisconsin Institute for Law and Liberty. Hi, Luke. Welcome to the show.
Hi, thanks so much for having me on.
This is one of those, again, we're going back to crazy school territory here. This particular case, it sure seems to be dragging. This is the Kettle Moraine School District case. We have talked about this on my program before, but it was all the way back in 2021 when this happened. Parents found out that their children were being transitioned by the school district without telling the parents. And this isn't the only school district doing this, but this is the case that you're dealing with today. So what's going on? Why is it taking so long? And what did you guys at Will try to do to move this along today or in the last couple of days?
Yeah, so just to refresh your listeners, there are a number of school districts, both in the state and around the country, that have policies to allow minor students to change their gender identity at school without notifying or getting the consent of parents. We have 3 active lawsuits against school districts in Wisconsin alone on this subject, against the Madison School District, the Kettle Moraine School District, and the Eau Claire School District. And the Eau Claire case, we represent some parents whose daughter wanted to transition. She was going through some mental health issues that spiraled into believing she was a boy. She wanted to transition, but her parents decided that would not be in her best interest. They told that to the school, and the school basically said, sorry, too bad. We're going to respect your 12-year-old daughter's decision rather than you as the parent. So they did what any parents would do. They pulled her out of the school district. And then came to us, and we sued the school district over that when the district refused to back down or change its policy. So the case has been, we've been litigating the case, briefing it. It's taken a while because we submitted expert testimony in the case, actually some significant expert reports from 2 of the leading experts in the country on this topic. But last Wednesday, we had a hearing before the judge, a summary judgment hearing, which is essentially an argument asking the court to rule on the merits about who wins the case. And so we're very optimistic that the judge will rule in our favor. He clearly got the argument, got the point, asked a number of very tough questions of the district. So hopefully we'll have a resolution soon. At this point, we're just waiting for the judge to issue his decision.
All right. So that you've already done the presented the arguments, and now we're waiting for the judge. Why is it taking so long? Was it the expert testimony? Was there, so much delay? I mean, this was post-COVID, so how did this drag on for 2 years?
It hasn't been quite that long. It's been 1.5 years, but the district started with a motion to dismiss, and so we briefed that and argued that. We won that initial round, and then you get a schedule for summary judgment, and we've been briefing that since then. The expert piece of it took a little bit longer, but we felt like it was important to have testimony from experts in the case to establish that a gender identity transition during childhood is a very serious decision with long-term consequences. There's actually a lot of experts around the world who believe that students, young people should not immediately transition when they struggle with their gender identities, that they should take time to process what they're feeling and why. And there's actually a number of studies that have shown that the vast majority of kids who deal with this ultimately find comfort with their body. And in fact, that's what happened to our client's daughter, right? She was struggling with her gender identity. Her parents pulled her from school, and within a few weeks, she changed her mind. She realized that her mother was right, and even told her mother that all of the adults around her who at her school and at a mental health facility who were pushing her to transition to being a boy because, the sooner she did it, the better, were actually confusing her and had made it worse. And once she was pulled from that environment, she realized that her mother was right.
And mom knew it all along.
That's exactly right.
Yeah, mom knew this, but the mental health professionals, all the adults who aren't going to be the ones picking up the pieces of this kid's mental health, they knew what's best for this girl. And they have this policy. So in this policy, now Sheboygan Falls, we learn that the superintendent of Sheboygan Falls claims it's against the law to respect the parents' wishes, unbelievably. So that may be a case you're going to be taking up the moment somebody decides to reach out to you on that. That's what administrators are told. We can't respect the parents' rights. We must respect the children's rights. Where does that come from? State law gives parents the authority to consent to medical treatment. State law. Our Constitution protects parents, not schools, who are acting as parents because they choose to. So how did we get here?
Yeah, it's basically a big game of telephone, if you're aware of that. A number of groups have gone around telling school districts that this is required as a matter of Title IX non-discrimination law, but that's simply not true. There's nothing in the law, no statute, no regulation. There's not even guidance from even the Biden or Obama administrations that suggest that Title IX requires schools to disregard parents about this serious mental health decision. And that argument just doesn't even make any sense, right? Schools require parental consent for all sorts of decisions. You can't take an aspirin at school without parental consent.
Title IX doesn't erase parental consent. Yeah, Title IX doesn't erase parental consent. But, I mean, Luke, surely they have lawyers that they hire. I know they do, because in the case of Sun Prairie, a reporter who reported on Sun Prairie got a letter from their lawyer. So don't the lawyers know better than to believe this bunk from activist groups that Title IX absurdly would require an obliteration of parental consent?
You would think so, but some of the lawyers are the problem, to be honest. So Kettle Moraine, the district that we're suing in Waukesha County, doesn't have a written policy about this. Dealt with the issue when it came up on an ad hoc basis. They consulted their lawyer, and their lawyer told them, you have to disregard the parents. Now, they're being sued over that, and in court, they can't actually defend that, so their lawyer was wrong to tell them that. But this has been repeated so much by groups that I think, people who have sort of bought into this idea are repeating it to school districts, and that's part of why we're bringing our lawsuits to communicate to school districts. No, actually, this is not only not required by Title IX, but it violates parents' constitutional rights because they are the decision makers with respect to their kids. And I would note that since we brought those suits, a number of school districts around the state have, to their credit, adopted policies requiring parental consent for gender identity transitions at school, but there are still a number that are holding out, and we are hopeful that courts will clarify this and issue a decision that strongly supports parental rights in this context.